Hello, my friends. Welcome back to Breakfast with Sergio. I'm here once again on this series of copyright laws with our good friend Jaime Guzmán, attorney at law here in Chicago. Hi, Jaime. Good morning again.
Good morning. Thank you.
Happy to have you on this series that we are doing on copyright, which you've been giving us some amazing information, breaking down the law so that we can understand them better, so that we can be better prepared as artists as well. And today we're going to talk about utility versus separability. And this one particularly is a special episode for sculptors, fashion designers, jewelry makers, craft, and many other like more utilitarian objects as well. Uh, Jaime, please help us out understanding utility and separability. What does that mean?
Absolutely. So, as you know, a lot of artists, they use different mediums to create their art, and as you already mentioned, it could be sculpture, it could be jewelry, it could be things that you wear. It could be something as simple as a belt, right, and a belt buckle. Belt buckles, they could be quite a fashion statement. They could be,
Yeah.
in many cases, certain artists, they put a lot of time and effort into the design of it, right? Because it's not just something that you wear, it's also something to make a statement with. So there's other things that you can do that with as well, including jewelry, right? And one of the things is to keep in mind is that the law looks at this as, well, the thing you created, it's interesting, it's got some cool sort of angles and some cool sort of turns, and it's maybe got a cool object coming out of it, but is the purpose of it more for utility, as in what it's being used for, or is it being used as art, right?
Okay.
Think about, like, for example, like a sculptor that designs like a cool lamp.
Right. So
But
it has both purposes, right?
Yeah, exactly. And so it's like, well, what's the main purpose of it? Is it to serve as a lamp, or is it to serve as a piece of art, right? And so one of the things to sort of keep in mind with this sort of thing is you want to make sure that you create something that allows you to separate the design aspect of it from the utility, right? One of the things that people run into is, well, I created something, and I spent quite a bit of time on it. I really thought it out. Yeah, you can wear it, or yeah, you can use it to hold something, right? But to me, it's a piece of art, and at the end of the day, it's like, well, I understand the ornamental side of it. I understand that you've added this, you twisted it this way, you did whatever with it. But at the end of the day, is it just being used to hold up your pants?
Yeah.
Right?
and is that decided by the user or by the artist? Who decides that?
Right. So here's the thing. That's one of those situations where, as an artist, you put your stuff out into the world, and you're never, sometimes you don't know how it's going to be interpreted, how it's going to be used, right? You might have intentions for it, you might have a vision, and you might have already thought about, well, this is exactly how I want this to be used. But we all know that in the world, there are people that are going to decide to do something else with it, and it could just be that it's for utilitarian purposes. If it's strictly for utilitarian purposes, it is very hard to maintain a copyright on that design. Okay. Even if you file a copyright, the way they'll assess it at the U.S. Patent and Trademark Office. The way they're gonna interpret this at the Library of Congress is gonna be, well, is this thing separable? The design is the design separable from the utilitarian aspect of it? And if it's not, if there isn't enough features that are separate from the utilitarian aspect, then what's going to happen is this person is going to lose their copyright. And if that person loses their copyright, then anybody's going to be able to manufacture that thing. And they're going to be able to do it without that person's permission.
Right, right.
So in essence, you end up you end up losing your copyright because it's falling into one of those categories that no longer merits copyright protection.
So the best advice for artists who are doing this sort of more work that has a utilitarian purpose, or like you said, like the lamp or something, what would be the best thing that they could do to protect themselves?
So this is a more complicated business model for an artist, because now they're going into the product side of things, right?
Right.
And so when you go into the product side of things, there's more legal implications. There's product liability behind it. There's dealing with the manufacturing process of this, because now you're not dealing with an individual work. You're dealing with mass production of something, because that's part of your business model.
Right.
So with that said, you really do have to consider how this is going to sort of be laid out from a business standpoint, and what your business approach is going to be looking forward down the line. Just like any other business that's putting out products, you really do have to make sure you study your market, have sort of focus groups to see how it is that people are receiving your work, what they're going to do with it, so you get an understanding. And that's what I mean by it becomes a more complicated sort of business process, because any product, if you look at it nowadays, there's, the business behind it is definitely doing a year or two of studying it before they even put it out. Right.
But what if the object is a one of a kind? Let's say the guy who makes the lamps, it's a one of a kind lamp. It's not really manufactured. It's still a lamp, but it's one of a kind because it's been handmade, hand designed. But he puts it, or she puts it, as a lamp. It's important to identify from the beginning as a work of art.
Yeah, absolutely. Absolutely. When you register the copyright for that, you want to make sure that it falls in one of the copyrightable categories. For something like that, you would be in what's called the pictorial, graphics, and sculptural works of the Copyright Act.
Wonderful.
You have to be intentional about delineating which specific category you're going to copyright it as. But then, you run into this issue of, well, yeah, I have this lamp and it's original, for example, and it's a great piece, it's a great sculpture. I don't want anybody else reproducing it, right? Because I want it to stay as a one of a kind, right? You might get into a battle about, well, no, it's utility, right? You might have, for example, the largest lamp manufacturer in the world decide, well, we really like your lamp. I mean, we know that you only want it for yourself. Sergio wants it just in his living room and no one else.
It's a nice lamp, man.
Yeah. But then they're going to say, well, lots of people would love this lamp in their home. We want to make it.
Wow.
And they can literally take it upon themselves to sue you and take you to court to have the court decide whether or not you merit a copyright based on this lamp. And to make a distinction between the utility and the design aspect of it, and whether it's separable or not.
Right. And I think that's one of the instances where, it is something that you're doing, that's your business as an artist, to really consult with people like you, with experts in law that can help artists kind of figure out, delineate those things, which are, very important for us, and not like say just go and do thinking that nothing is going to happen, but really be prepared, consult with the experts in cases like this.
Well, right. So when an artist is sort of delving into this realm, you really do have to have a good team around you, right? I mean, because there's a lot that goes into products and putting products out in commerce. And it's not just, no longer is it just about your copyright and your work. Now it's your business revolves around selling these products. And what does that mean to you? And who are the people that are going to help you manage that, right? And that's a whole different sector of responsibility outside of what copyright law brings. Now we're talking product liability law, which brings in other torts and other things. And then we're talking about contractual obligations that can come from dealing with manufacturers and that sort of thing. So it really does become elaborate once you go into that phase of your work and your business. And so it is important to have the right people around you. Absolutely.
Awesome. Well, thank you so much, Jaime. This has been a beautiful episode again. Awesome information you have provided us. And my friends, if you enjoyed this episode with Jaime and I, if you had a good chat this morning here with us, and as you having your own breakfast, please share it with a friend. That's something that we would really appreciate if you just click share on that little button, or you subscribe if you're watching on YouTube, or share it if you are listening to the podcast. However way you are consuming this content, this awesome series that we have here with Jaime, please share it with your friends. That will make us really, really happy, so more artists can be prepared, to face these legalities and be ready. So thank you again, Jaime. Happy to have you once again here in Breakfast with Sergio.
Thank you. Good morning.
Thanks.